is Supreme Manouevers, Supreme Court, and the India Reborn. The French philosopher Montesquieu, when he was outlining his theory of the state, he said that a modern state should have what he called separation of powers. That is, a division of the powers of the state between three organs, namely the legislative, the executive, or the judiciary. And in between these three organs, there would exist a system of checks and balances, thereby not allowing any one particular organ to arbitrarily dominate or cross its domain of function and infringe upon the domains of the other two organs of government. Now, coming to the peculiar case of India, in 1950, more precisely the 26th of January 1950, the Constitution of India came into force. The Supreme Court of India, which was formerly known as the Federal Court in the colonial times and was newly designated as the Supreme Court of India, was designated as the organization which would act as the guardian of the Constitution, which would celebrate the Constitution, which would guard the Constitution against the onslaught from other organs of government. And truly, the Supreme Court has played a stellar role in the history of independent India in protecting the rights, the civil liberties, and the fundamental necessities of a citizen's life in a modern Indian republic. In a string of landmark cases, the Supreme Court has very carefully calibrated the relationship between the different organs of government, the organs of government vis-à-vis the citizens, and the citizens with respect to each other, thereby creating a gradual, incremental, and organic Indian democracy which borrows its best constitutional principles from other constitutions around the world, but gives them a unique Indian touch, peculiarly suited to local circumstances, local needs, and necessities. And it has also made dynamic interpretations of the Constitution and the law, keeping in pace with the times. The topic I specifically wish to dwell upon today is the landmark judgments delivered by the court in the year 2018 and what implications they have in the life of the common Indian citizen as he becomes a member and a participant and an adult franchisee of this modern 21st century democracy. The year 2018 saw two Chief Justices, Chief Justice Honorable Deepak Mishra and Chief Justice Honorable Ranjan Gogoi. Honorable Chief Justice of India Deepak Mishra retired towards the end of 2018. But before he left office, he ensured that the Supreme Court, along with his learned brother judges, that it delivered a series of very fundamentally crucial verdicts in different facets of public life, which would go on to completely change the contours and fashion a new fabric, social, political, and demographic fabric of the Indian nation. I am here today to discuss some of these crucial verdicts. Let us start with the peculiar case of Shyam Narayan Choksi. Shyam Narayan Choksi in 2001 went to a screening of the movie Kabhi Khushi Kabhi Gum. As you may possibly remember, that in between the movie, a rendition of the national anthem was played. Shyam Narayan Choksi was affronted or displeased when he realized that most of the people in the hall did not stand up to respect the national anthem. And when he stood up, others booed him and asked him to sit down so that he would not obstruct the view of the film. So Shyam Narayan Choksi approached the Madhya Pradesh High Court, citing Article 51A, which is the which deals with fundamental duties in the Constitution and which requires of every Indian citizen to respect national emblems, national flags, national symbols, etc. But the Madhya Pradesh High Court was then to say that a film or the screening of a film is not an ideal ground for the testing of patriotism, and therefore standing up in the middle of a movie whenever the national anthem was played or before the screening of a movie would simply cause a lot of inconvenience and obstruction, and this was possibly not a right forum. The case finally got its verdict in the Supreme Court in the year 2018, where it was said that first of all it would be mandatory to play the national anthem before the screening of all movies in cinema halls, and the citizens, barring those who were disabled or incapable because of any other reason, were to pay their respects to this national symbols and to this national anthem by standing up during the national anthem. Later on, this mandatory requirement was reduced to a discretionary requirement, because the Supreme Court also realized that maybe people go to cinema halls for unobstructed entertainment, and the cinema hall probably isn't the best place for them to give the litmus test of patriotism. Now I come to the important case of Common Cause Registered Society versus Union of India. Now, Article 21 is one of the fundamentally enshrined cardinal principles of the Indian Constitution, which gives the right to life and liberty. Article 21, as we all know, in the Constitution has been a wellspring of fundamental rights, of derived fundamental rights. Now, Common Cause Registered Society simply argued in front of the Supreme Court that the right to a dignified life should also include the right to die with dignity. What does this mean? That if a person is chronically and terminally ill and has no possible hope of recovery, or is in what we call a PVS, or a persistent vegetative state, then that person should be given the liberty to be given passive euthanasia, thereby to rid that person of his misery, and to make a living will, to give the person the discretion to make a living will while he is alive, to be given passive euthanasia in case he falls prey to any of these unfortunate circumstances, to not prolong his misery, but to give him passive euthanasia. This was a very progressive judgment as far as the right to live and die with dignity was concerned. Now, I come to the case of Joseph Shine versus Union of India. Section 497 of the Indian Penal Code used to deal with adultery, and this was a more than 150-year-old law that existed from the colonial times. But the wording of the statute was extremely patriarchal and constricted. The man was to be penalized and jailed if he had established relations with a married or an unmarried woman. For a married woman, her only penalty would be that she would be deprived of maintenance if a suit of divorce was to be instituted by her original spouse. Whereas she was let off scot-free, the man was jailed and punished. This implies a very patriarchal understanding, whereas sexual intercourse, whether during marriage or extramarital affairs, is always a consensual affair. And therefore penalizing the man only is a very myopic and Victorian colonial view of things, and therefore this was read down by the Supreme Court, and section 497 of the Indian Penal Code was declared unconstitutional. Thereby adultery ceased to be a criminal offence and just became a ground for divorce proceedings. For us, this was civil proceedings essentially, just a ground for divorce. That's it, no more a criminal offence. Now, to the fundamental case of the Aadhaar privacy, which was Justice Puttaswamy, retired, versus Union of India. In this case, the Supreme Court made the landmark pronouncement that the right to privacy is an essential and integral component of the right of life and liberty, and therefore it is an extremely essential derived fundamental right, thereby elevating privacy to the status of a fundamental right. While dealing with certain sections of the Aadhaar Act, the Supreme Court discovered that some of them did not abide by the necessary requisite requirements that are required of any democratic legislation, and they were infringing upon the liberty of the individual on certain grounds of national security. So that particular section relating to the exemption dealing with national security was struck down and declared unconstitutional, whereas most of the other parts of the Aadhaar Act were deemed constitutionally valid, provided that Aadhaar would not be asked for in essential services such as banking, delivering of gas services, admissions to schools, and all the other essential facets of a person's life. Aadhaar would not be a necessary requirement, and therefore Aadhaar was held to be constitutionally valid. It was held that passing the Aadhaar bill as a money bill was not an abrogation or fraud upon the constitution, but the purview of Aadhaar was significantly reduced. And the Supreme Court also asked the government in no uncertain terms to ensure more stringent security for Aadhaar data to stop them from falling prey to the hands of private corporations who might misuse them for their own business motives. Now I will deal with my final case in this particular discourse, which is the very crucial, landmark, path-breaking case of Navtej Singh Johar versus the Union of India. In Navtej Singh Johar versus the Union of India, section 377 of the Indian Penal Code, also again another 150-year-old law, which prohibited sexual intercourse between two consenting homosexual adults and declared it an unnatural act based on Victorian morality, was struck down. The beautiful phraseology used by the Supreme Court in this judgment was something like this: I am what I am, so accept me as I am. And the Supreme Court was bold enough to adopt the extremely modern outlook of considering a person's sexuality as a spectrum, thereby not reducing it into watertight, disparate compartments, but rather to see it as something fluid, a person's gender and sexuality as something fluid, and thereby declaring that once two consenting adults decide to have sex, the state has no authority or purview to barge into their bedrooms or to arrest or penalize them on moral grounds, thereby upholding the Delhi High Court judgment of Nas Foundation versus Delhi NCT, and thereby making a landmark move in favor of liberation of the LGBTQ couples and their liberation from social ostracization and exclusion. I would at last briefly deal with the Sabarimala judgment, which was the Indian Young Lawyers Association versus the state of Kerala. Rule 3B of the Kerala Places of Public Worship Act prohibited menstruating women between the ages of 10 and 50 to enter into the Sabarimala temple, which is a shrine dedicated to Lord Ayyappa, who has millions of followers around the world, particularly because it is considered that the Lord Ayyappa is a celibate deity. And the entry of women into the sanctum sanctorum in their menstruating age would somehow violate this sanctity of the shrine. And this was subsequently embellished by the accounts and rituals formed by the tantris, who were the chief priests there. The Indian Young Lawyers Association filed a case way back in 2006, challenging this extremely discriminatory and downright ostracization rule, which prohibited women to get into the sanctum sanctorum of the shrine, and thereby the Supreme Court in its judgment simply said that after reading the principles of the Constitution, after a harmonious construction and joint reading of the Articles 14, which deals with the right of equality, 15 and 16, which bar discrimination, 19, which deals with the freedom of speech and expression, and 21, which deals with the right of life and liberty, Rule 3B of the Kerala Places of Public Worship Act was declared and deemed completely unconstitutional and discriminatory, and the Supreme Court, by a 4:1 majority judgment, allowed women to enter the main shrine and sanctum sanctorum of the Sabarimala temple. This led to considerable social friction, a lot of conflict between people who thought that the state should not infringe upon matters of religious faith and freedom, and between secular forces who had to say that modernism and rationality, which was enshrined as the fundamental principles of the Constitution, should apply without exception to all public institutions, including temples and religious shrines. So this conflict went on, and this is conflict that is still raging between devotees and people who support this judgment. So this was, in brief, a small journey, in very brief, summing up the important judgments that the Supreme Court of India gave in 2018. It was a very eventful year as far as the Constitution was concerned, and as far as constitutional liberties and the rights of citizens were concerned, and it fashioned new benchmarks and new milestones in the constitutional history of not just India, but also South Asia, and by extension, the world. I express my profound gratitude to the Kashi Manthan organization for giving me this opportunity to come before you today and explain to you in a very brief manner the important constitutional developments that happened by virtue of the Supreme Court and its decision in the very pivotal year of 2018. I hope to come back to this forum time and again, and I hope to interact with you once more on some new topic which affects our rights, liberties, and duties as citizens of a new Republic of India. Thank you so much.